Hi, everyone. Thanks for joining us. So we're super excited today to have Matt Reardon here. He is a partner at Goodwin and works in the business law department. And he's also a lawyer in residence at HBS. So Matt's going to walk us through company formation, common mistakes, and pitfalls. So we're going to cover quite a bit throughout the presentation. So we'll ask everyone at the end of each slide if you have questions to raise your hand then, and Matt can cover questions as we go throughout the presentation. And we'll also have plenty of time for individual questions at the end. I do see quite a few cameras off, so if folks could please turn their cameras on now. If you're having any technical difficulties, just reach out to me and let me know. But we do ask that everyone keep their cameras on for the duration of the session. And so with that, I will turn it over to Matt. Thank you.
Great. Thank you very much. I want to thank Ben and Emily for having us here and the Rock Center in general, and also everyone for joining us and taking time out of your day to be with us today. So as Emily mentioned, my name's Matt Reardon. I'm a partner in the Tech and Life Sciences group at Goodwin in the Boston office. I'm joined today by my associates, Wen and Ivanka, who you might have met at the iLab. They're two rising stars in our Tech and Life Sciences group, also in Boston. So today, what we're going to discuss are some key pitfalls that founders sometimes encounter when forming their businesses. And more importantly than identifying the pitfalls is giving you the information of how to avoid them and address them. So as Emily mentioned, we'll have a few slides. At the end of each slide, we'll have a chance for questions if people have them. And then at the end of the presentation, we'll have more time. So we want to make this interactive and make sure that your questions are answered. So feel free to jump in. I'm going to share my screen, and so you can see the slide deck. So the first issue that we want to discuss are paying attention to corporate formalities. So when you are starting your business, one of the first steps is creating the business entity itself. And one of the key reasons that forming the business entity is important is because business entities like a corporation or a limited liability company, if the corporate formalities are respected, create a shield from liability for the stockholders and founders personally. So the way to think about this in very simple terms is if you started a business out of your home, you were selling a product and you were just selling it individually, the customers might have a claim of liability against you. Whereas if you create a company and you're selling your product through the company, in most cases, if you respect the corporate formalities, the people would have a claim against the company, not against you personally. So at the base level, that is one of the key reasons to create the corporation or LLC and to respect the corporate formalities so it's treated legally as a separate entity. When I say treating it as a separate entity and respecting corporate formalities, that means things like actually forming the business and filing the paperwork in your state of incorporation, keeping that paperwork up to date, setting up a separate bank account for the entity that's separate than your bank account, having board meetings, signing things on behalf of the company rather than in your personal capacity. There is just the general acts of treating that entity as separate from you is the key. And I'll put in a quick plug here, and we'll touch on this later in the presentation for the Goodwin Founders Workbench. It's a totally free service that will help you create the documents you need to form your company. As I mentioned, entirely free, no commitment. If you use it, it's at foundersworkbench.com. You use it, you enter your information, and it creates customized formation documents for you that will help you respect these necessary corporate formalities. The other key to respecting these corporate formalities and creating an entity is, for most innovative, high-growth businesses, the key assets they have, at least at first, are their IP. And in order for the company to own the IP, the company needs to exist. And so in order for you to have a company that could attract investors and customers, et cetera, you'll need to have an actual entity that's holding that IP. So that's the first step, paying attention to corporate formalities. And I'll pause now if there's questions, or else the next slide is on choosing the form of corporate entity that you'll actually use. So I'll move on to the next slide.
Sorry, I see one question from Tyler.
Yeah, sorry. I just had a quick question about, I guess, timing of forming corporate entities with regards to IP. Do you think like filing for corporation before filing for patents is necessary, or could that order be reversed? What are your thoughts on that?
So the order can be reversed. The way to think about when to form your entity is, as soon as you have a valid business idea and you think that you are going to have a business, I recommend forming the entity. And that's because the earlier that you can form your entity and give yourself equity of that entity and get the IP into that entity, when the value of that company is low, the better tax position both the company and you will be in. The actual cost of creating a company is relatively low. It's not zero. You have to pay filing fees, but there can be very large benefits to getting your equity in the company very early on and getting all of the IP the company may own into that company very early on for tax purposes. So generally, the earlier you can form your entity, the better.
That's great. Thank you.
Great. So the next slide here is on keeping the formation process simple. So the titles of these slides are based on kind of pitfalls. So the pitfall here is complicating the formation process. The idea here is that people, potential investors, customers, partners, they are going to look at the value of your business based on you, your team, the product you create, your business, not the form that the business takes. And so keeping the formation and the structure of your company simple is typically the best way to allocate your resources. So there's two main types of entities that people typically use to form their early stage companies: the corporation and the limited liability company. There are benefits of both. My first top level comment will be, unless there is a very good reason for using a limited liability company, and sometimes there is, most often it makes by far the most sense to use a corporation. So I would think of the corporation as the default and the LLC as sometimes appropriate in very specific circumstances. I'll give you the high level on LLCs first so that we can then jump into corporations, which are much more common. LLCs provide the two benefits that LLCs provide. One of them relates to taxes. So LLCs are pass-through entities. That means that the LLC itself is not taxed, its owners are taxed. That means there's one level of taxation if you use an LLC. If you use a corporation, the corporation is taxed on profits, and then when it distributes out those profits to its stockholders, the stockholders are also taxed. So In a corporation, there's 2 levels of taxes. In an LLC, there's 1 level of tax. So LLCs can result in tax savings for some businesses. The second is that LLCs are extremely flexible. So the statutes that govern LLCs, very flexible. They are creatures of contract, which basically means, for the most part, the agreement amongst the owners of an LLC are just what they put in the operating agreement for their company. That can be a huge benefit if you have very sophisticated parties working with very sophisticated counsel. It can also be a downside in that there's way more things that you could potentially incur costs in, create unexpected pitfalls, go down rabbit holes that don't provide value to your business. So like a top level is LLCs in very specific circumstances can provide powerful tax benefits and powerful flexibility, but they're way more expensive to get there, way more expensive to maintain. And if you are expecting to take money from venture capitalists or other types of investors, frequently they're not able to invest in LLCs. And so outside of very specific circumstances where an investor is willing to incur a lot of additional expense themselves to structure their investment into your business, if you go out and find investors, they may say, before I invest, you have to turn into a corporation. So that's kind of the LLC. The corporation is by far the most common form of entity we see for early stage companies. LLCs, if you formed an LLC already and you want to convert to a corporation, that can be done. It's a fairly common conversion. Going the other way, going from a corporation to an LLC is extremely difficult, and assume that you can't do it because it's very complicated, can be very expensive. The benefits of a corporation are that they are simple, they're very well understood, there's very developed case law around them, and very importantly, they're much easier to issue equity to employees in. There's a very standard form of employee equity for corporations that are stock options. The LLC, everyone who holds equity in an LLC is a partner in that LLC, entitled to certain information about the entity that founders frequently don't want to provide them with. So it's much easier to provide equity to employees in a corporation. There are 2 key types of corporation: S corporations and C corporations. A C corporation can provide you with some of the benefits of an LLC. It has 1 level of taxation, which is the key thing that it can give you that's like an LLC, but it still has all the benefits of the corporation. So a lot of times what people do is they will, when they initially form their company, they'll form it as an S corporation. The S corporation has certain restrictions that come along with that tax benefit, which are that only US humans can be stockholders in SCorps, and you can't have more than 100 stockholders, and you can't have different classes of stock. So basically, you can only have 1 class of stock. It can only be held by US tax-paying human beings. So it can't be held by another company. And you can only have 100 stockholders. If you break any of those rules, you just become a C Corp. So there's no real penalty other than once you don't comply with these S Corp rules, you are a C corporation. So a lot of people form as a S Corp, and then down the line, if it turns out they want to take money from VCs, which aren't individual humans, or they want to create more than 1 class of stock, they become a C Corp, and they continue their corporate existence as a C Corp. So that is the slide on the formation entity. Are there any questions that we can address before we move to the next slide? And I'll just show you the next slide so you know what's coming up. It's on founder equity.
Yeah, and actually we did before you move on, actually Lapita has a question.
Sorry. Yeah, hi, thank you. I wanted to know if you could describe the difference between a B Corp and a C Corp, or maybe benefits of one versus the other.
That's a great question. So a B Corp, there's kind of two things. There's a B Corp and a benefit corporation. A statutory benefit corporation is a separate category under the Delaware corporate statute. And what a statutory benefit corporation, the key difference between a C Corp and a statutory benefit corporation is that in a statutory benefit corporation, the directors of the company can take into account a broader range of constituents when they think about how to fulfill their fiduciary duties. So in a C Corp, the directors have fiduciary duties to the common stockholders. That is their primary duty. In a statutory benefit corporation, they can take into account a larger range of constituencies. So rather than just taking into account the pecuniary interests of the stockholders, they can also take into account the impact the business has on its community, like its partners, etc. So it basically gives the directors of the corporation a broader range of things they can consider when fulfilling their fiduciary duties. A B Corp is kind of a seal of approval you can get from a third party kind of evaluator. It's not a statutory distinction. It's more of a certification from a third party that you've met their standards for being a B Corp. And I saw a question about services that can help founders create corporations or LLCs. I would say if you go to the Founders Workbench, the Goodwin Founders Workbench, it's a free service. So I know there's services out there that charge a fee. Founders Workbench has no fee. It's also created based on our experience working with thousands of startup companies and investors. So it's really, those forms are developed to be something that investors will recognize and will work so that you could take investment in the future. The next slide is...
I just had one quick question, if that's okay.
Yeah.
One question was around how expensive it is to convert from an LLC to a C Corp and how complex that is. I know you said it's pretty common. And then the second question was around the starting as an S Corp versus a C Corp. I may have missed this in the nuance, but what is the benefit of starting as an S Corp versus just automatically starting as a C Corp?
Yep. So
thank you.
Converting from a LLC to a corporation will the cost and expense and complexity of that will totally depend on how complicated your LLC is. So if you just formed an LLC, it has no commercial contracts, it has one owner, then that could be a pretty straightforward conversion. If you have an LLC and it has many owners, it has different forms of classes of equity, you have lots of contracts you've signed up with third parties, that could be much more complicated. So it's really a sliding scale. Then The second question was on why to form an S-Corp rather than a C Corp initially. So the S-Corp has the same benefits as a LLC in that it has one level of taxation. So if you never had to do any of the things that brings you into C Corp territory, such as creating a second series of stock or bringing in non-human stockholders, if you were to go sell the company, you could have some significant tax savings selling a company that's an S Corp rather than a C Corp. So there could be reasons to start as an S Corp. And that way, if you never needed to do any of the C Corp things, you could exit in a way that was more tax efficient. I want to make sure that we move on to founder equity so we get through all of the topics. So the next piece is, the next pitfall is failing to appropriately address founder equity. So there's a few things I want to discuss here. One of them, and this is a question we get very frequently in office hours through the iLab and through the Rock Center, is what's the best way to think about allocating equity amongst founders? And the short answer is there's no set rules. It's more art than science, which is not the most satisfying answer. What we find is most often sets companies up for success is very early in the company's life cycle. So if possible, at the time of formation, just having very open and transparent conversations amongst the founders on what the founders' past, present, and future contributions to the company are likely to be, and allocating equity in the company based on the extent of the past, present, and future contributions to the company. The best outcomes for companies typically flow out of addressing this as early as possible in the company's lifespan. The other thing to remember is these things can't be known totally at the time of formation. You may have your plans of how people are going to contribute to the company in the future, but those may change. And so there's two things that you should keep in mind when you're dividing up equity for how your company can adapt to those changes over time. So one of them is subjecting founders' equity to vesting. And in simple terms, what vesting means is that although a founder gets all of their stock at once upon formation, a portion of it is subject to forfeiture if they leave the company. And that forfeiture condition kind of burns off in stages over time. So you hold the equity, but you could lose it if you leave the company, and you earn the right to hold it in perpetuity by staying with the company. The most common vesting schedule, and this is not, there's no requirement that you use this, this is just industry practice, is for stock to vest over 4 years with 25% of it vesting after 1 year. So nothing vests for the first year. Then upon the 1 year anniversary, 25% vests. And then typically the rest of it vests either monthly or quarterly over the next 3 years. So it takes 4 years to totally vest. Like I said, that's not a legal requirement. That's just business. That's the practice in the industry. And it's really important in our view to put vesting on shares up front so that if things don't work out, if someone decides they want to leave the company, they don't walk away owning a big chunk of the company. That's the type of thing that could really put your company in a very difficult situation over its life, because it just reduces the amount of equity you have to give to investors. and also importantly, to other people you'll bring in as employees or consultants who will help you grow your business. And the other thing I want to mention, I said there was 2 ways to think about adapting ownership over time. In the future, you'll have a incentive stock pool, and to the extent that ownership does not match people's contributions to the company or does not provide enough incentive for people to stay at the company over time, you could issue additional equity in the form of options to people in the future. You don't want to go in planning to do that for founders, but it is something that is not uncommon to do as the company grows and the founder suite changes. So I mentioned that putting vesting on shares can be very important for the success of your company over time. It is absolutely critical, and it's underlined in this slide, that if you subject your shares to vesting, that you file what's called an 83B election with the IRS. The most important thing to remember is this is extremely important to do. It can have very, very adverse tax impact on you and the company if you don't do it. And critically, there's a 30-day period from when your shares are subject to vesting to the deadline for filing. And if you don't file within those 30 days, there's no way to file in the future. There's no exceptions, there's no extensions. You have to do it within 30 days. I'll give you just the highest of level description of what the 83B election does, but most important is to remember how important it is to file it and file it quickly. So from the IRS's perspective, when you get your shares, if they are subject to vesting, if they're subject to forfeiture, the IRS takes the position that the taxable event of you acquiring those shares does not occur until the forfeiture conditions burn off. So if you were to issue yourself shares when you first form your company and it has nominal value, essentially no value, and you pay full value for those shares, you say the company is worth $100 and you pay $100 to buy all of the stock. If you file an 83B election, you're telling the IRS, I know that I might lose these shares in the future, but I want to pay all my taxes on them upfront. And I paid full value for them. And so there's no tax right now. If you don't file the 83B election, let's say you paid $100 for the company, and in 1 year, your company's worth $10 million, and 25% of your shares vest, the IRS will say you paid $100 for the company, and now it's worth $100 million. And you own 25% of it now, so you have a tax bill on that. Every time you vest, you have a tax bill based on the value of the company at that time. So as the company grows in value, your tax bill would increase and increase. And your stock is most likely illiquid. There's not really a good way to turn it into cash to pay your bills. And you wouldn't want to do that. So for that reason, this can be disastrous if you don't file your 83B. So wanted to make sure we made that clear. And then the last point on founder equity is after you've made all of your splits and you've allocated your founder equity, typically people enter into a stockholder agreement that restricts the ability of the founders to transfer their shares. Because if you have a group of founders, you likely want the shares to remain in their hands, so they are incentivized to continue to provide value to the company. You wouldn't want them selling them to, a family member or a competitor of your business, etc. So typically, rather than just a flat restriction on transfers, the founders agree that before someone can transfer the shares, they first have to offer them to the company and then to the other founders. And so if the company wanted to buy them or the other founders wanted to buy them, they'd have a chance to do that before they get outside of the company. And I think we had a few questions on this slide, so I'm happy to address any questions people have.
Yes, we did have two questions. We have a question from Teresa asking about the example that you gave on vesting. Is that a 4-year vesting schedule with a 1-year cliff, meaning you would be fully vested in 5 years? Could you talk more about using a cliff?
Yep. So you can structure this however you'd like for your business, but the most standard is 4-year vesting with a 1-year cliff. So what that would mean is on day 1, you say all of my shares are vesting subject to a 1-year cliff of 25% and then equal vesting over the next 3 years. So on the 1st year anniversary, you'd have 25% vested, 75% unvested. And that 75% that's unvested would vest in equal proportion, so equal chunks, either monthly for 3 years or quarterly for 3 years. So the cliff, you could do a 20% cliff and then have 4 years of vesting after that, but the total 4 years is the most standard approach.
And then another question from Sarah Scott. Just to be clear, even if we own 0 shares upon filing, for example, we subject all shares to vesting and own 0% at the onset, we should still send in the 83B.
That's correct. So the distinction here is that when the company is formed, you will buy the shares, so you'll own them. The issue is that they're subject to forfeiture. So you own the shares, but if you left the company, they would revert back to the company for those shares that had not yet vested. So you'd be filing saying, I own all the shares I bought, but they're all subject to vesting. So I'll go on to the next slide. The next slide here, another pitfall, failing to raise enough money for fear of dilution. So this is pretty straightforward, and this will be a quick one. Here, the general idea is everything costs twice as much as you think it will. Everything takes twice as long as you think it will, including raising more funds in the next round. And the key to remember, and I touched on this before, is your corporate structure, your fundraising, your cap table, all of those things are not what will get people excited about your company, whether they're the employees you want to hire with equity, the investors you want to incentivize to invest in your company, the corporate partners you want to sign up. They will be excited about you and your business. And so all of this legal stuff we talk about is super critical to get right so that your company can succeed, but you don't want them to be the focus of your time. So raising enough money so that you don't have to spend your time fundraising again is the outcome you want. And that's kind of the last bullet point here, which is when you're raising money, it is a full-time job, along with your full-time job of running your company and growing the business. It really can be all-encompassing. And so you're going to be devoting all of your energy to the company, and suddenly you'll be devoting all of your energy to the company and to fundraising. And the fundraising piece is a necessary evil. Running your company is why you got into the business. So just making sure, focusing on having enough cash to be able to run your business effectively and get to the next inflection point where you'll be able to effectively raise money is the most important thing. Obviously, you should be rational, and you don't need to take tremendous funds that you don't need that create dilution, but assume that everything will be more expensive and take longer than originally anticipated. Any questions on this slide? And I think I saw a question that came up about the last slide, but I didn't quite catch it.
We did have a question. Sorry, I'm trying to see if we have any hands up. I don't see any hands. We did have a question on the previous slide about what is an IPO lockup.
Yes. So an IPO lockup is something that's on that slide, and it's another restriction on transfer. So I mentioned that founders typically put restrictions on the transfer amongst them and their co-founders so that the shares stay within the company. An IPO lockup is slightly different, and typically something that's less important for founders to worry about, because usually before your company would do an IPO, you've brought in money from VCs who will make you put these other transfer restrictions on your shares anyway. But a lockup for an IPO is that for a certain period of time after the company goes public, you would be unable to sell your shares in the public market. And the reason you put that on is that if founders sell their shares after a company goes public, it can send a message to the market that the founders aren't, if the founders want out, why would anyone else want to be in? So it can have a negative impact on the value of the shares. So founders frequently are subject to an IPO lockup, which restricts their ability to sell their shares following a public offering.
And we have another question in the chat regarding the ROFR on the previous slide. Does it work the same in a C Corp as in an LLC? Should it go into the operating agreement?
The short answer is yes. Transfer restrictions would work the same in an LLC as in a corporation. So this next slide, next pitfall, spending money too quickly, is a corollary to the last slide. So another pitfall, spending your money too quickly. Two things that come up a lot in office hours here. One of them is hiring. Who should you be hiring at the early stages of your company? Typically, if you form the business and you and your co-founders have a lot of the skills necessary to run an early stage company. So things like hiring a chief financial officer who's not a founder, hiring a chief operating officer, people who would require large compensation packages frequently just aren't that necessary early on in a company's life cycle. And instead, the founders plus the skills they need to fill the gaps in terms of technical on the ground work is typically a more efficient and productive way to spend the company's limited resources. The other thing to think about here is using equity compensation rather than cash compensation, especially early on in the company's life cycle. You typically will have an incentive equity pool that you create as part of creating your company. Use that to hire and incentivize employees. It really has two huge benefits. One of them is it doesn't require cash, and the other is it's the best possible way to align the incentives of the company with the incentive of its employees. And like a founder's equity, it would be subject to vesting. So again, not only are the founders and the employees economically have the same incentive, but in terms of keeping their equity, they have the same incentives. So saves resources and aligns incentives. It's an incredibly powerful tool for bringing on and retaining talent in a way that allows your company to succeed. This next pitfall, failing to pick advisors who add value to your business, is in line with the last two. So all of this goes to your company has very limited resources. How do we best use them? Picking the people who you will allocate those resources to, picking people who provide value is going to be key. So choosing investors that you will be selling your equity to, investors who more than just bringing money to the table are providing you with terms that allow your company to grow successfully. So when you evaluate term sheets from different investors, look at the amount of money they're willing to give you and the valuation they're putting on your company, but also consider the kind of other contractual provisions that go in there. How much control of your company do they expect? How much are they going to restrict you from operating your company? And on the flip side, how much will they be providing to you outside of just their money? So will they be serving on your board? Do they have business experience that they can use to help you grow? Do they have business connections, either with other investors or with potential customers? Basically, what do your investors bring to the table beyond just the money that's going to go into your bank account? Same thing with directors, and I kind of touched on this, is there'll be a limited number of people who can really sit on your board. Make sure you're filling those seats with people who provide value to your company. And then in terms of service providers and advisors, there's sometimes an instinct to kind of get a large advisory board of people who have been successful, who will look good on your website, etc. And that can be very valuable, but typically those people expect some type of compensation. And frequently it's in the form of equity. For early stage companies, usually not cash, but your equity and your cash are very limited resources. So making sure that you are allocating those to the people you're bringing into your company who can really add value. And a trick that experienced founders use to make sure they get value is the same way you put vesting on the shares that you give to founders and to employees. You can put vesting on the equity that you provide to advisors and put a requirement that they meet with your management team once a quarter and that they're available by phone. And if they don't, live up to their end of the bargain, that you can terminate their advisor agreement, and they, to the extent they didn't vest in their equity, they would go back to the company. So any questions? I kind of ran through those 3 slides, which I think are all related. Any questions on those? Okay. And then this last pitfall, which is failing to adequately protect your intellectual property assets. This is a really important one. So protecting your intellectual property assets is critical for the success of your company. And it's something that investors or acquirers are going to be very focused on, especially if you have an IP-centric, innovative, high-growth type company. So how do we think about protecting your intellectual property assets? What does that mean at a high level? So one of those things is making sure that the IP that you have, this first bullet point, rights of former employees, former employers, you want to make sure that as founders, when you first start your company, that to the extent you're starting your company with a business that is similar to maybe somewhere you worked before, that you have similar ideas, similar IP, making sure that as a very base first action, that that IP that you're going to use is not owned by your former employer. And a corollary to this is, I believe everyone on this call, or many of the people on this call, are current either Harvard students or faculty or related to Harvard. Make sure that the IP that you are basing your company on is not owned by Harvard. And that is not uncommon. You can work with Harvard to either make sure it's clear that it belongs to you, or to the extent that it truly does belong to Harvard, that you get a license from Harvard to be able to use that IP. And none of these issues are insurmountable. They're just things that you should make sure you understand and have very clear documentation and clarity on before you start growing your business. The next piece here is the rights of consultants and other third-party developers. This goes to everyone who is working for your company should sign an agreement that says everything they create belongs to the company, not to them. That applies to you as founders, to all of your employees, and any consultant you hire. You want clear documentation that everything everyone creates when they're working for your business belongs to your business, to the company itself, rather than a third-party consulting firm, rather than an individual. You, as part of that, when you form your company, you want to make sure that any IP that you created before you formed the actual entity, you contribute to the company. The high-level idea here is that all of the IP that might be part of your business, you want to make sure that it is fully and clearly owned inside your business rather than anywhere else. And then, similar to the IP ownership piece, is the protection of that IP. And that comes down to both contractually making sure that everyone who has access to your company's IP or confidential information signs an agreement saying that they won't disclose it or use it. And so that's an NDA. That's really important. Have everyone sign NDA, which covers them disclosing the information and using it in any other way. The other thing is, though, NDAs can be very difficult to enforce. And so in addition to kind of the legal contractual protections, just keep in mind the safest way to protect your IP is to restrict access to it. And that sounds like super obvious, but people can be surprised at how difficult it can be to enforce an NDA. So you have to prove that someone had access to your information, that they then disclosed it on purpose. There's all kinds of ways you have to prove that it's been breached, which is not impossible, but again, is not how you want to spend your time and resources as a founder. So any questions on this slide? And I'll say we have about 9 minutes left. This was the last substantive slide. The next slide is just a reminder to use the Goodwin Founders Workbench to create your documents. And so we've come to the end of what I would say is the substantive piece of the presentation. And now we just open to questions.
Amin is wondering, can you explain securing IP?
Yeah, so I think that when I think of securing IP, I think of the two things. One is, as I said, making sure that your company owns the IP. So that is legally assigning everything that founders and service providers create to the company. That's the one step of securing the IP, it's making sure it's within your business entity. And then the second piece is making sure that everyone who has access to your company's IP has signed non-use and non-disclosure agreements. And then the third piece is having in place policies that restrict your company's confidential information to only those people who need to have access to it. And so that, in many frequently means kind of staging information. So different people within your organization and third parties may have access to certain types of information, but not all of it. The safest way to keep your company's IP private is to restrict access to it.
And then we have another question in the chat. What should interns be signing?
Interns should be signing the same documentation that an employee would sign. So when an employee comes on, when I talk about an NDA with non-use and confidentiality provisions and the assignment provisions whereby people assign all of their IP that they create to the company, the intern should sign those too. And those agreements will include other things as well, typically. So they'll usually include provisions that prevent employees from disparaging the company, that require that employees don't, while they're working for your company, don't compete against you by working with other companies. Now, as you may know, certain states, including Massachusetts, have restrictions on how enforceable non-compete provisions can be. But a typically enforceable provision is that while working for a company, you can't work for another company that competes against it. The restrictions on non-competition provisions typically apply to post-termination non-compete provisions.
Okay, and then question from Brent. You advised incorporating early. Many vests are pre-revenue, pre-incurring meaningful expenses, pre-fundraising, etc. What are the milestones that you would say trigger a need for incorporation?
I would say once you have a viable idea that you think you are going to use to build a business that eventually will raise capital, will have revenue, etc., that's a good time to incorporate your business. The downside to incorporating early is that there is a filing fee in your state. And that is really the main downside. Then there's every year you'll have an excise tax due. So basically, there are fees associated with incorporating. They're not huge, but they're not zero. But that is I think once you have an idea, and you think that you're going to pursue it as a business, that's a good time to incorporate. And critically, that allows you to, one, buy the equity of your company for a very, very low cost and file your 83B so that you've locked in your tax treatment and you've acquired your shares at a low cost. And the other piece is that allows you to put IP into the company early on before that IP may have a lot of value that would be taxable to the company. So once you have ideas, which are IP, and a plan to pursue them as like a real business concern, that's when you should start thinking about the cost benefit trade-off of incorporating.
And we have a question, why would VCs prefer a C Corp structure versus an LLC if an LLC has only one layer of taxes?
That's a great question. So there's two main reasons. The first one is that because an LLC is a pass-through entity, the profits flow up to its stockholders. Many VCs have nonprofit equity holders in their entity. So the VC fund that will invest in your business may have either foreign or nonprofit investors. They are very sensitive to incurring tax consequences from pass-through entities. So VC funds typically, to invest in a pass-through entity LLC, would have to create what's called a blocker, which just creates a lot of additional cost and expense, all kinds of stuff. So that's the main reason, is it can have tax impacts for them that make it very expensive for them to invest and maintain their investment. The second piece is that VCs are extremely familiar with how laws are interpreted in corporations that are formed in Delaware. They know the fiduciary duties of directors that sit on the board. They know the rights of stockholders who own the shares. They know what the documents are going to look like. Whereas LLCs have totally different fiduciary duties. Their documents can be very different than what people are used to seeing, and they don't provide the protections for stockholders that VCs are used to. So it's really around uncertainty in the rights they'll have and potential negative tax impacts.
All right, awesome. Well, we are at time, and I want to be mindful of Matt's time here. And I know other folks may be taking lunch breaks during the day, et cetera. So thank you so much, Matt, for taking the time to do this for us. As Matt mentioned, we posted the Founders Workbench.com to the Rock Summer Fellows Coda, so you can use that as a resource. And thanks to everybody for taking the time to come to this session today.
And I'll just throw in a plug. First, I want to thank Emily and Ben again for organizing this and letting us speak with you today. I want to thank everyone on the call for joining and asking questions that made this really interesting and useful. And I want to say that I have office hours through the Rock Center that people can sign up for. And also, if you have questions, feel free to check in with me or Wen or Ivanka. I think, let me just go down. Our email addresses are right now on the screen with our full names. Feel free to get in contact with any of us. Wen and Ivanka, I selfishly used up all the time here, but they are excellent members of the team. They know their stuff. And if you have questions, you can reach out to them as well. And we are excited to be able to help you and hope that this was helpful and that you go forward and are extremely successful in your business ventures.